Hello again friends, welcome to the Supreme Court Historian YouTube channel. We are going to look at our fourth landmark judgment today, decided on the 26th of May 1950, Dr. Narayan Bhaskar Khare versus the state of Delhi. This particular judgment deals with Article 19 once again, another fundamental right enumerated in that article. Clause 1 subclause D, that is the right of every citizen to move freely throughout the territory of India. And Dr. Khare is our most distinguished petitioner so far. He was a medical doctor, got his degree from the Lahore Medical College, but originally from the central part of India. He had earlier studied in Jabalpur, and Jabalpur, Nagpur, that was his area of operation. He was a member of the Congress party from 1916 till 1938, and he was a very senior leader as well. He had been a member of the central provinces provincial legislature. He had been the leader of the Congress provincial committee as well. He had been imprisoned during the civil disobedience movement, and he had also been the premier, or that was the term used for the chief minister of provinces under the Government of India Act 1935. So when the first elections to the provincial legislatures were held, he had been elected in the central provinces and Berar legislature, Berar being the Anglicization of Warad. Anyway, he was elected as the head of that central province's government. The post was then known as the premier. So he was a very senior politician, and only in 1938, after differences with the Congress policies, that he quit the party and he joined the Hindu Mahasabha in 1938. He became the president of the Hindu Mahasabha. He was also held under house arrest after the assassination of Mahatma Gandhi, and then later on in the post-partition era, he was involved in making a lot of speeches opposing and criticizing what he and his organization, the Hindu Mahasabha, called the appeasement policies of the Jawaharlal Nehru government, appeasement towards the minority community as it was. So all of these were his activities in the lead up to these events. And these events were kicked off on the 31st of March 1950, when the District Magistrate of Delhi served Dr. Khare with a 3-month externment order. He was ordered to leave the district of Delhi and not return for 3 months. This order was made by the District Magistrate of Delhi under Section 4, subsection 1, clause C of the same act that we have looked at in the Brij Bhushan case, that is the East Punjab Public Security Act 1949. And we will look at that provision in a bit. The next fact, as it were, was that Dr. Khare approached the Supreme Court, claiming that this externment order violated his right under Article 19(1)D, that is of course the right to move freely throughout the territory of India, and hence Dr. Khare decided to exercise his fundamental right under Article 32 of approaching the Supreme Court to quash the order through a writ of certiorari. So first let's look at the externment order itself. Quoting from it, your activities generally and particularly since the recent trouble in East and West Bengal have been of a communal nature, tending to excite hatred between communities, and whereas in the present composition of the population of Delhi and the recent communal disturbances of Delhi, feelings are aroused between the majority and minority communities, your presence and activities in Delhi are likely to prove prejudicial to the maintenance of law and order, and it is considered necessary to order you to leave Delhi. This was the crux of it, these were the words in that externment order. The order was made under section 4 clause 1 subclause C of the East Punjab Public Safety Act 1949. I have summarized the provision that it says that the provincial government or the district magistrate, if satisfied with respect to any particular person, that with a view to preventing him from acting in any manner prejudicial to the public safety or the maintenance of public order, it is necessary to do so, may by order in writing give a direction that such person shall remove himself from and shall not return to any area that may be specified in the order. That is section 41C of the East Punjab Public Safety Act 1949, which though passed by the East Punjab provincial legislature, it was also extended to the neighboring district of Delhi, under which therefore the Delhi district magistrate had the authority to give such an order to any citizen residing in Delhi, which happened to be Dr. Khare. So the argument being made is that his speeches were inciting feelings that in the already roused community, the already roused communities rather, the majority and the minority communities in Delhi, and were likely to therefore be prejudicial to the maintenance of law and order in that state, in that province, in that district of Delhi. Prejudicial to the public safety and maintenance of public order. This was the crux of 41C. And when we look at the clauses of the provisions of the Constitution that were being infringed as claimed by Dr. Khare, we will realize that public safety and public order have no place in this particular right. Article 19 clause 1 subclause D provide the citizens of India the right to move freely throughout the territory of India, and 19.5 restricts this freedom, that the state may by law or by an existing law impose reasonable restrictions on this right to move freely throughout the territory of India in the interests of the general public or of any scheduled tribe. But the scheduled tribe part of this clause does not arise over here. That part is in case there are certain areas customarily inhabited by any scheduled tribes, then the movement of other citizens into that scheduled tribe area may be restricted. But that is not in question here. What is in question here is the interests of the general public. So this is much more wider, isn't it? These restrictions on the right to move freely throughout the territory of India are wider than the right to freedom of speech and expression. Freedom of speech and expression could be restricted only under the laws of defamation or contempt of court or security of the state. That is what the situation was back in 1950. But the right to move freely throughout the territory of India could be restricted under this vague term, in the interests of the general public. So it was going to be easier for the government to defend this particular externment order compared to what it had to do in the Ramesh Thapar and the Brij Bhushan cases, where the right to freedom of speech and expression had been restricted. So the arguments made by Advocate B. Banerjee on behalf of Dr. Khare, Advocate Banerjee had also assisted in the Ramesh Thapar case, and the Attorney General Mr. M.C. Setalvad on behalf of the state of Delhi. The argument made for Dr. Khare was that the externment that was ordered against him was in order to suppress political opposition to the government. What Dr. Khare was claiming was that his speeches were merely opposition speeches, opposition to the government, and opposition to the elected government cannot be against the interests of the general public. The opposition leaders, their whole purpose is to uphold the rights of the general public which might be infringed by the government. It's a very straightforward argument, and it's a very intelligent argument as well. What he had to prove, though, was that those were merely opposition speeches and nothing more than that. In response, the Attorney General argued that the restriction of the right granted by 1920 provides the procedure for that restriction is provided in the Act itself, so it cannot be unreasonable. He was focusing on whether the restriction was reasonable or not, and since the procedure for the restriction was given by the Act was not a blanket provision that anything can be restricted. The restriction was given quite reasonably, that an externment order cannot exceed 3 months, and if it was to exceed 3 months, then the opportunity would be given to the recipient of the order to make a representation of himself, and hence it was not an unreasonable. In response, Dr. Khare's argument was that yes, although there is a 3-month limit on an externment order, there is no limit as to the renewal of an externment order. That is, as soon as 3 months were up, the person would be asked to be externed once again, would be ordered to leave the province once again for another duration of 3 months, and for another duration of 3 months after that, and so on ad infinitum. Therefore, it could be an indefinite externment, and therefore it would be an unreasonable restriction on the right to move freely throughout the territory of India. In response, the Attorney General pointed out that the East Punjab Public Safety Act itself would cease to be in force after the 14th of August 1951. So these externment orders, these apprehended externment orders, these feared externment orders which would have been kept on getting renewed, would cease after 14th August 1951 anyway. A technical argument that they cannot be indefinite, they cannot go beyond 14th August 1951 anyway. So it would still be possible to extern somebody for a period of more than a year. For example, Dr. Khare had been externed on the 31st of March 1950. So the externment could go on for 15 months almost, but not beyond that. That was the argument, but it was a sufficient argument, as it proved to be the case, that since the Act itself would cease to be in force after the 14th of August 1951, since the Act itself had a specific life span, and it was quite clearly enacted during the post-partition period to try and maintain public order and safety, and it was hoped that by that time, by 14th August 1951, things would have simmered down, the government would have been able to control things comfortably, and therefore there would be no need for such a seemingly draconian act which allowed the infringement of freedom of speech and expression, as we have already seen. Section 7(1)(c), Section 7 basically of the East Punjab Public Safety Act in the Brij Bhushan case, and now Section 4 in the NB Khare case. These provisions would not be needed after some time had elapsed. How much time? Provisionally 14th August 1951. This was sufficient, but only just. This was the first time that we have seen such a close decision. 5 judges heard this case. Justice S.K. Das was not part of the bench that heard this particular case, and these 5 judges were split in the closest possible margin. 3-2 was the result. Chief Justice Kania, Justice Patanjali Shastri and Justice Fazal Ali held the order, the externment order, to be valid, held that it did fall within the scope of Article 19(5), that is, it was a reasonable restriction in the interests of the general public to extern Dr. Khare from Delhi for a period of 3 months. The argument that the Act could be abused is a mere apprehension, and an act cannot be held void on the basis of a mere apprehension, was the contention of this 3-judge majority. This is once again an indicator of this being the early period of the constitution, when the courts were willing to give governments the benefit of doubt. Later on, of course, we have seen that even apprehension of abuse of enactments has proved sufficient for the higher judiciary to hold any particular enactment or a provision within an enactment to be void. Interestingly, Justice Mukherjee and Justice Mahajan dissented with this majority opinion, with this slim majority. Chief Justice Kanya wrote the majority opinion and Justice Mukherjee wrote the dissenting opinion, holding that Section 4 does provide unreasonable restrictions, because the fact that the act itself would cease to be in force after 14th August 1951, that was not sufficient to restrict these indefinite externments, because as we have seen with the Preventive Detention Act, that was during the A.K. Gopalan case, we have seen that that kept getting amended and extended beyond its original end date all the way to December 1969. So for 20 years that act kept on being in force, although it was supposed to cease to have effect after just a year and a half. Something similar was apprehended by Justice Mukherjee, with Justice Mahajan consenting that the fact that the act was going to cease to be in force after August 1949 was not enough to ensure that it would not be abused. And this slim majority was all that stood between the voiding of the East Punjab Public Safety Act 1949, I beg your pardon. Now this is this particular margin of the majority makes us speculate what would have changed the mind of one of the majority judges, perhaps Justice Patanjali Shastri, the likeliest of the three to hold in favor of the petitioner based on the judgments that he had written in the in the Brij Bhushan and the Romesh Thapar cases, which were decided earlier on that same day. And if we speculate a little bit, we realize that actually the matter was quite close to being decided in the other direction. There is a mention in the judgment of another order that had been passed against Dr. N.B. Khare. This was a very interesting order. Once he had received the order to leave Delhi on the 31st of March 1950, he was on his way to his native place, that is Nagpur, all the way in the center of the country from the north. And during this journey, he received another order, this time passed by the Madhya Bharat government, where he was headed. And the order was that he should remain within the limits of the city of Nagpur during his externment from Delhi. Now this was quite interesting, and this would have perhaps, in my opinion, proved to be fatal for the East Punjab Public Safety Act, because now it was being used, not that act but something else was being used in a very arbitrary manner. Not only was Dr. Khare being externed from a particular district, he was now being called upon to stay within a particular city, and if he wanted to leave that city of Nagpur, he would have to take the permission of the Nagpur district magistrate. For speeches which he had made in Delhi, he was being asked to stay within Nagpur. This was a very good example of abuse of power by the executive, and perhaps unsurprisingly, through some coordination, this particular order of the Madhya Bharat government was revoked even while Dr. Khare's case was being considered by the 5-judge Supreme Court bench. So let us speculate if this order had not been revoked, it would have been easier for Dr. Khare to point out to the Supreme Court, to that 5-judge bench, that such arbitrary powers were being used by the executive of one province or the other. And asking somebody to leave a province is one thing, asking him to not leave any particular city and not go in anywhere else in the country was a completely different thing. And if that order had not been revoked, perhaps the Supreme Court might have realized that the government is acting in an arbitrary, unreasonable fashion. But this, as I said, is merely speculation. As it was held, as it was decided, Dr. N.B. Khare's externment was found to be valid by the Supreme Court, and it proved to be a landmark judgment which was referred to in future cases until, of course, the post-emergency era of our jurisprudence. The Supreme Court was not going to listen to any such arguments. But that comes much later in the picture. We are still in 1950, although we are now coming to the close of the landmark judgments in that first year of our republic. Just one more to go in this 1950 period, but our agenda for June is already complete, and this is just the second day of June. So hopefully we are on track to finish all the 75 years of the Supreme Court's landmark judgment history by the time the Supreme Court completes 75 years of its existence. Hope you have been enjoying these videos. Hope they have been instructive. Keep the feedback coming, and we shall keep our journey going. Thanks for listening. See you next time. Bye-bye.